Welcome to tonight's webinar, Law Talk, Tenure and Other Employment Issues. Tonight's Law Talk is by professional educators of Tennessee's General Counsel, Mike Sheppard. Mike Sheppard attended the Salmon P. Chase Law School, where he earned honors in criminal trial practice and Dean's List designation. He has been a lawyer for 33 years, managing law partner, and taught at paralegal institutions, and is admitted to practice in Ohio and Tennessee and before all Ohio and Tennessee courts. Mr. Sheppard is passionately dedicated to empathetic, knowledgeable advocacy of its members and the teaching profession. And now we will change screens and begin the webinar. Thank you.
Hello, everyone. This is Mike Sheppard. Glad to have you with us this evening. Tonight we're going to be talking about tenure mainly, but we're going to be discussing other employment issues as well. So, you know, keep your keyboard and pens ready because we're going to be wanting to take questions and answer them as they are sent to us. So, again, welcome to our presentation. First of all, we need, and not knowing exactly who we have in the audience, but I would like to talk a little bit about who is eligible for tenure. Sometimes that's an obvious question, but sometimes the legislature has decided to change their standards a little bit. So let's go over that very quickly. Eligibility for tenure. As a teacher in Tennessee, you must have a 4-year degree, you must have a valid teaching license, and you must have completed at least 5 years of teaching, and an overall evaluation of above expectations or significantly above expectations as provided in the evaluation guidelines, which, if you would like to write this down, is under 49-1-302. And those of you who really want to become quasi-lawyers, first of all, you can't do that without going to law school, but you can get on the statute by getting on LexisNexis. Part of the relationships LexisNexis has with the state of Tennessee, allowing them to provide legal services and search engines in Tennessee is to allow the public access to Tennessee Code Annotated. So if you ever want to review Section 49, which is the education part of our code, our code of Tennessee Code Annotated, just put Tennessee Code Annotated and Lexis will pop up. Hit that screen and you can search this section and read it for yourself. Much of it is written in simple language. Some of it's ambiguous, some of it is not specific enough, and our legislature does get some criticism for maybe not listening to teachers sometimes before they write the statutes. But we as a trade organization try to make that happen every day. So if there's anything that you see in the statute or live with every day that you think you shouldn't have to live with, or something that's confusing, please let us know as an organization so that we can effectively lobby on the Hill and change those that legislature so it best represents our members. And we will reach out to you time to time for that feedback. Eligibility for tenure, I would assume that that's adequate explanation of that area. The real question that comes up many times is, the probationary period. A teacher on probation remains on probation until they have completed all the requirements for tenure. Some interesting things about the probation area of tenure is what happens if you quit after you obtain tenure or after you're past probation. One interesting aspect of the 49.5.504 probationary statute, it allows you to return to teaching without probation if it's waived by the Board of Education. Otherwise, you have to serve a 2-year probationary status after resigning. That is something that a lot of people don't know. It's good to know with teachers leaving, taking leaves of absences. It's always good to know whether you can just come back or whether you have that 2-year probationary status to face you. Also, after you receive your tenure status, you can temporarily lose it, and that is by having 2 consecutive years of evaluations demonstrating below expectations or significantly below expectations as provided by the guidelines of the State Board of Education, which is under 49-1-302. And you will be returned to that probationary status if you have those 2 consecutive designations until you've had 2 consecutive additional years of evaluations of above expectations or significantly above expectations. So it's important to realize that, you know, once you gain tenure, it's not just, you know, I have it forever. And most good teachers are aware of that, and they maintain their level of performance each year commensurate with the requirements of a tenured teacher. But just remember those provisions in 49.5.504. Do we have any questions out there yet from anyone?
No questions yet.
Okay, we'll keep moving. No questions yet. Okay. Very important to remember is that the local Board of Education has the authority to set the standards of employment over and above those set by the State Board of Education. The State Board of Education is a minimum, but they can, the LEA has the authority to set the standards for performance for teachers. And of course, those really must gain the approval of the State Board of Education, but the local standards vary. And that's why from, I don't know, Pickett County to, say, Davidson County, you may have some different requirements. But that's allowed under 49.5.506. So again, it's important to remember that these are not always state standards, but you know, the Board of Education does set the overall standards, but additional standards can be set by the local Board of Education. So any questions there?
A question that came in was, is it possible to transfer my tenure from one district to the other, like if I change from Davidson County to Williamson County?
You know, I've seen it done, and I've seen it done under the old law. I don't see it in the statutes here allowing it, but I believe that it is allowed by practice. I've seen teachers tenured and transferred to other districts, and at times they've been on probation for 2 years and then they gain their tenure back. So that is a very good question, and I would look at the practices. Right now it's unclear whether the statute allows that or not, but as a matter of practice I do see it done. Has anybody out there seen that it's been done or heard of it being done, or actually been involved in that? No? Well, if you do, I'd like to hear about it because I've had a couple of instances where I have seen it done. I think it's a good law. If it's not codified in the new group of statutes, which I don't see it, I think it should be. I believe it was possible under the old law, and I think many districts are operating under that law. So anyway, that's something that I'm going to look into and do a little research on after this presentation and try to get out to our members an update on that question because it's a little hazy right now. So again, local standards apply, simple enough. And breach of contract. What happens if you want to resign or if you break a contract? I get these questions all the time. How do I resign? Does this action by the teacher constitute a justifiable reason to breach the contract? One of the first things you face usually is the resignation. If a teacher gives the director of schools notice of resignation at least 30 days in advance of the effective date of the resignation, and you fail to do that, you will forfeit all tenure status. Although again, the board can waive that 30-day notice requirement and permit a teacher to resign in good standing. If you do break your contract with the Board of Education without a justifiable reason, and those justifiable reasons are as follows: the incapacity of a teacher to perform on the contract. That's usually evidenced by a physician and includes a doctor's note. But again, that physician has to be approved by the local Board of Education. So you have to be careful there and make sure that you get pre-approval before you get that doctor's note. Otherwise, you will have been deemed to have breached the contract, and it will adversely affect your tenure and your future ability to work in the system. The second justifiable reason is the drafting of the teacher into military service. And that's fairly self-explanatory, except when you start dealing with what do you do when you come back from the service. We've had some military, having grown up in the military and been around the military most of my life, I tend to relate to folks with military backgrounds. And it's amazing how many teachers we have that are veterans. But there's a law that's called URISRA, which means that when you do come back from your tour of duty, you're supposed to be put in the same position you were in before you left. And a lot of people try to change that around, but simply put, you're supposed to be put in the same job with the same pay and doing the same thing you were before. Now, if you settled for an equivalent position, then that certainly is your prerogative. But the law is very, very favorable to veterans. So that is not a breach of contract when you go on a leave for service or you're drafted. The other justifiable reason, which will not be deemed a breach of contract, is a release by the local Board of Education of the teacher from the contract with the local Board of Education. And if you would like to read more about this law and the annotations and some more explanation, you can go to TCA 495508. Now, what happens if you break the contract without a justifiable reason? Well, first of all, you will not be given permanent tenure status in any other school system in the state until you have met all the requirements in that system, that new system, for attaining permanent status, plus the serving of the 5 continuous years in lieu of the 3 consecutive years required. There are ways, to avoid the injury of the breach of contract by doing something else, making a decision. The board can later inform the commissioner, for example, that it is no longer holding the breach of contract against the teacher, and the local board can request the commissioner to notify the local boards in the state. If and when that board informs the commissioner it's no longer holding the breach, the teacher shall immediately become, that breach of contract shall become null and void. So that doesn't happen often, but it just happens just enough to make it interesting in this state as far as breach of contract. So any questions from the attendees? Any questions regarding probation, tenure, breach of contract, or anything we've covered thus far?
None so far.
Okay. Let's move on to...
No, but I do have... Can you hear me, Mike?
Yes.
I do have the answer to our tenure question. Essentially, according to TCA 49-5-509, a director of schools can pretty much do whatever they want with a tenured teacher who comes into their district. If a teacher has tenure, they can serve the regular probationary period in the new district, or the local board can waive the probationary period and grant them their tenure status, or they can shorten the probationary period. So it can range from, we recognize your tenured status, welcome aboard, to your 5-year start all over again.
Oh, okay. What statute is that?
49-5-509, and that is subsection B.
Subsection B, 509. Okay. All right, well, that answers that question, and that's why people are doing it. And that's why we're involved in those situations where we see our teachers go between districts and are able to switch. I think that's a good law, and probably should be exactly that. Good teachers do move, and they shouldn't have to. But again, it's the director of schools. It appears has a lot of the power and authority and discretion, correct?
Yes, that's correct.
Yes, and we are for local discretion.
Yeah. 49-5-511, we're talking about causes for dismissal. Obviously, the first and one that I guess everyone hears and about at each end of each school year, not always, is the non-renewal, and that is involving the non-tenured teacher. I mean, the causes for which a teacher may be dismissed or suspended are incompetence, inefficiency, neglect of duty, unprofessional conduct, and insubordination as defined in 49-5-501. Along with that, a director of schools may suspend a teacher at any time they may seem necessary, pending investigation or final disposition of a case. This becomes a very important issue in a teacher's career when they do not feel that the suspension, dismissal, or whatever it might be is justified. And when that involves a tenured teacher, it does trigger some responsibilities and due process rights that are made available in the statute. However, some of the local policies and procedures at a minimum need to meet the requirements of the Board of Education and the statute, but there are some subtleties and some changes you might see in local board policies. But under 49.5.511, under dismissal or suspension of teachers, if the matter under investigation is not the subject of an ongoing criminal investigation or Department of Children's Services investigation, and no charges have been made, a suspension pending investigation shall not exceed 90 days in duration. If indicated, the teacher will be paid the full salary for the period during which the teacher was suspended. When the charges are made, they have to be made in writing, stating the offenses that are charged, and signed by the party or parties making the charges. If in the opinion of the board, the charges are of such a nature as to warrant the dismissal of the teacher, the director of schools will give the teacher a written notice of this decision, together with a copy of the charges and a copy of a form, which gives you the additional rights that you have under the statute, legal duties, rights, and recourse under the section of the policy. But you need to check the board policy as well as to what's required, what is provided, what the intermediate reviews may involve. It could be meetings. It could be, let's go back to causes for dismissal here for a minute. When it becomes necessary to reduce the number of teaching positions because of a decrease in enrollment, the board is empowered to dismiss such teachers or non-licensed employees based on their level of effectiveness pursuant to 49.1.302 for licensed employees and an evaluation of work performance for non-licensed employees. The board has to give the teacher or non-licensed employee written notice of the dismissal, explaining fully the circumstances or conditions making the dismissal necessary. If a teacher is dismissed and they're in the three highest categories based upon evaluations outlined in 49.1.302, they be construed, nothing in this section will be construed to deprive the director of schools of the power to determine the filling of such vacancy on the basis of the director of schools evaluation of the teacher's competence. So it's not an all to end all here. The right to remain on that preferred list is outlined in the statute. Again, this does happen. You can remain on that preferred list until you accept a bona fide offer of reemployment, or the teacher reflects 4 bona fide offers of reemployment for comparable positions within the LEA. So again, this can be different from district to district. I will say that if there is dismissal, you're a PET member, professional education, educators of Tennessee, you should call us right away. You should probably have some notice prior to any such dismissal. Hopefully there has been some communication, but it's very important to protect your rights, meet your local deadlines as well as the statutory deadlines for appealing the dismissal. So those are the causes for dismissal. Any questions at this point?
No questions.
Appealing a dismissal, a teacher must request a written notice as outlined in 49.5512. A tenured teacher who receives notification of charges within 30 days after receipt can demand a full and complete hearing on the charges before an impartial hearing officer selected by the board as follows. And again, I'll just back up for a minute. How this works is it's normally an arbitrator is usually selected and agreed upon by the parties. The director of schools names the impartial hearing officer, and the hearing officer shall direct the parties or the attorneys to appear before the hearing officer for simplification of issues and scheduling of the hearing. The pre-hearing conference occurs. You have an arbitration. Impartial is defined in the statute. And it's pretty, I don't know, at times, I've seen it not be as impartial as I'd like it to be, but it's defined in the statute as being the selected hearing officer shall have no history of employment with the board of director of schools, no relationship with any board member, and no relationship with the teacher or representatives of the teacher. Now, if you have an arbitrator that consistently holds for the board against a teacher, that's difficult to handle sometimes, and you have to work a little harder to convince that arbitrator that that the evidence is insufficient to meet the standards of dismissal or suspension. But I have actually appealed those to the arbitrator, and I think you really have to, because you still are not limited just by the arbitration. You do have an appeal after this. So I always leave the academic or the administrative record intact regarding my objections to the impartiality or partiality of the arbitrator. That's just my style. I think it's important to have those minutes of that meeting and that court reporter, which there is a court reporter there, to have entered into testimony my basis for the lack of fairness or the lack of impartiality. So all the testimony is under oath. A record is kept. Witnesses are given fees and mileage just like they are in court. And again, as I said, an transcript is made of the hearing, and a record of the hearing is usually prepared and paid for by the district. You can sequester witnesses. It's very similar to a courtroom hearing. At the discretion of the arbitrator, you can have opportunity to file briefs, propose findings of fact and conclusions of law as you do in a regular case, and you can propose initial or final orders. Then the hearing officer, within 10 days of closing the hearing, can decide the disposition of the case, and thereafter gives the board and the teacher the written findings of fact, along with the conclusions of law and a concise and explicit statement for the basis of the outcome of the decision. Now, 49.5512 goes on and talks a little bit more about what you can do if you're dissatisfied with the decision, but let's take that point by point, since it's very important to at least be aware of your rights to appeal this phase of the hearing of the dismissal. First of all, you can't sue the director of schools, so that's, for pursuing charges and prosecuting charges. So I've had teachers ask me, how can a director who is possibly just wrong, be not held accountable? It's written right in the statute. And I will say that most directors, after you get through the system and challenge them at the early phases, most of our directors do a pretty good job. If the affected teacher wants to appeal the decision, you've got to exhaust all administrative remedies. That's a rule of all administrative law. So you appeal the decision to the Board of Education within 10 days. If you don't hit that 10-day rule, or within that 10 days, you forfeited your rights. But the board has the option, and I've seen them do it, overturn the arbitration opinion, and it does happen. So don't take that phase lightly. It can be immensely helpful to your cause to get in front of the board members and plead your case with pet counsel. Upon written notice of appeal, the director of schools prepares a copy of the proceedings, transcript, and transmits a copy to the board within 20 working days. The board hears the appeal, and no new evidence shall be introduced at that time. The employee may appear in person and with counsel and argue why the decision should be modified or reversed. After the hearing, the board will render a decision within 10 working days after the conclusion of the hearing. Now, any party dissatisfied with this phase of the appeal and the decision rendered by the board shall have a right to appeal to the Chancery Court. In Tennessee, we have two court systems. We have a circuit court system and a Chancery Court system. Chancery Court, under common law, is traditionally a court of equity, where a circuit court is a court of law. Both can handle each other's cases. Sometimes in the smaller counties, the Chancery Court judge also serves as a circuit court judge. So it's not a firm demarcation between the responsibilities. So you need to appeal to that Chancery Court, and an attorney can help you with that in the county where the school system is located, and you must do that within 30 days after receipt of the notice of the decision of the board. Now, once you get to the Chancery Court, it's a trial de novo, which means everything is reviewed. And that means the record of the hearing officer and the board review, it should be reviewed all over again by the Chancery Court. It's not like the State Court of Appeals where you do not have a trial de novo. You only possibly could be arguing rules and the law, not the facts or the circumstances. But you can do that. That provides that very important right, 49.5.512 in Tennessee, to do just that. But again, the director of school shall also have a right to appeal. So as we continue through 49.5.512, which is a long statute, which it has to be because it provides a lot of rights and dates and basically appellate protections. It's a very, very important statute. The rest of the statute has um, has to do with subsections A and C that we just talked about don't really apply to the suspension of a teacher for a period of 3 days or less, and that is not made in anticipation of dismissal. For such suspension of 3 days or less, there are some other rules that need to be followed, such as director of school shall provide written notice of the suspension and the reasons for the suspension. Upon request made in writing within 5 days from the date of the suspension letter, the director shall provide a conference with the director. The meeting shall be recorded by the director of schools and a copy provided to the teacher. Upon request, the director shall issue a written decision within 10 days from the date of the conference, and if the teacher is dissatisfied with the decision, may pursue an appeal pursuant to 49-5-513, which is a judicial review. A tenured teacher, which is 49-5-513, and we talked a little bit about the Chancery Court and what it's there for. Again, you can petition for a writ of certiorari from the Chancery Court of the county where the teacher is employed. Some of the judicial review is somewhat redundant with the earlier statutes, and it shall stand for trial. It will be litigated, and a written record of the proceedings shall be made, and the findings of fact and conclusions of law. Any party dissatisfied with the decree of the court may appeal as provided by the Tennessee Rules of Appellate Procedure, where the cause shall be heard on the transcript of the record from the Chancery Court. So there's a lot of appeals that can be instituted, and teachers' rights are very well protected as far as the legal system is concerned. And even if you are dissatisfied with the Chancery Court, you can file an appeal with the Tennessee Court of Appeals, and then on to the Tennessee Supreme Court. So it becomes more and more judicial as you appeal further and further up the system. So again, anything less than 3 days is a different route, but you can still appeal that if you're so inclined to the judicial review after you go through a different system. So with that in mind, I'd ask you to check our website. Again, LexisNexis.com is where the statute is. Feel free to visit our website for more Law Talk presentations. And any questions at this point for anyone?
I don't have any additional questions, but if anybody who's viewing this webinar at a later time has any questions, they can send them to legal@proedtn.org. So if you're watching a reviewed copy of this webinar, send any questions to legal@proedtn.org.
All right, thank you very much.
Thank you.